Hello guys, welcome to my channel. Today we are going to see the possession, sale and distribution of SARFAESI Act. A very important concept which will be often tested in examinations, especially the law officer examination. Like I said, SARFAESI is for the banks or the financial institutions who has a security, who are the secured creditor. And one of the important concepts of security is mortgage, and the mortgage usually has a land or a building or a flat or apartment, whatever it is. And the important point with regard to is to sell the security, and from those proceeds you fulfill the default or loan. The most important thing with this kind of security is that you need to have a possession. Any buyer who wants to buy the property, they want to buy the property free of cost or free of unnecessary encumbrances. The property, they must have a vacant possession. But if somebody is already living there, or if somebody is refusing to give a vacant possession, then the buyer would think that he would be forced to do an endless litigation in removing the persons from that particular place. So the property would become unattractive, thereby fetching a very low or less value in the sale of either through auction or private treaty or whatever the method the authorized officer chooses to go. So how does the SARFAESI Act tackle this problem? Let us see. So in this chapter, we are going to see about the kinds of possession. There are two kinds of possession. One is symbolic possession, the other is physical possession. And remember, the word symbolic is not used in the act. It simply means that somebody might actually stay in the particular place. Say the borrower might be staying, because most of the mortgages are equitable mortgage. Equitable mortgage means mortgage by the deposit of title deeds. The title deeds are with the bank, however the possession is with the borrower. So the borrower might not be willing to vacate the place, or the borrower might have given the place to rent, uh, as uh, as somebody. There might be tenants living in the place, who might refuse to vacate the place. So in such situations, it is very important for the borrower to vacate the place. In sometimes the bank might not wait for the borrower to vacate the place. They might just go and put in option saying it is a symbolic possession. Symbolic possession simply means that the possession, the borrower or somebody is still in the particular house or immobile property. They would be expected to vacate it once the sale is done or during the sale process. Whereas, as opposed to that, physical possession means the bank would hold the keys to the property, and they would have the complete control over the property, which means a physical possession. So always having a physical possession is an attractive option, because the property would fetch a much better price in the auctions or private treaty, or the methods that is chosen by the authorized officer to sell. So, like SARFAESI Act, there is a corresponding enforcement rules 2002. So it talks about how the notice should be given. It talks about how the demand notice should be given, how the sale notice should be issued, what are the valuations has to be done. For example, if the property is about 1 crore or about 2 crores, it is always advisable to have uh, reports two valuation reports. And this is always an advisable factor. So how the valuation has to be done, and because the borrower might challenge this particular aspect, saying that the valuation is they have undervalued my property and sold it at cheap rates. So all these questions will come into picture. So it is always prudent to look into the enforcement rules before the sale, and the sale procedure has to be done. Like I said, right to property is a constitutional right in India, and to deprive someone of that, despite them having mortgaged the property, has to be done under due process. And the process that is set out in SARFAESI needs to be followed by the bankers in letter and spirit. In case if they do not do that, then the actions can be invalidated by the High Court or the Supreme Court. Then the concept of right of redemption. Right of redemption is a concept from transfer of property. So it is a very important concept, which means once a mortgage is always a mortgage. That is, the mortgager has every right to redeem the mortgaged property from the mortgagee, provided that he has fulfilled his dues. So, what is the right of redemption under SARFAESI Act? There are crucial Supreme Court decisions that has been given repeatedly, and we would see how and when the right of redemption stops. Uh, uh, there is a right of redemption. It is in favor of the mortgager, but however, there is a clicking time bomb. There is a time in which the right of redemption would be stopped. No longer it can be stopped, and it is irreversible. So when does that happen? We are going to see that, and the distribution of proceeds after the sale, how the proceeds are to be distributed. Now it's going to be always a problem that if there is a surplus amount, say for instance the loan is of 1 crore, and if the property is sold for 2 crores, how the 2 crores should be distributed, and whether the borrower gets extra uh, the extra amount after fulfilling the debts. All those things would be seeing in the distribution of proceeds. And say for instance, if the borrower does not have any for any surplus. For example, if the loan is for 1 crore and if the property is sold for 50 lakhs, then there is 50 lakh shortfall. The banks can actually approach DRTs and other forums to fulfill that shortfall. Let's see the two kinds of possessions. Like I said, there is a symbolic possession and a physical possession. Symbolic means like constructive possession. It's like in a paper, the creditor affixes a possession notice on the property, but the ownership control is not physically taken. The control is not physically taken. So that is one thing. But even there are properties that are sold in symbolic possessions. So you don't have to think that not don't have to think that it's always a physical position that goes on sale. There are some properties with symbolic position that can get to sale, because if the bank thinks that the property can easily be taken possession, then they can simply go ahead with the symbolic possession and issue the sale notice. Now physical possession is a much better attractive option. It is actually physical control of the secured assets taken, and sometimes the borrowers or some unruly borrowers might resist the physical possession. There has been times where the borrowers cleverly, with the good legal advice, would put in place some tenants in the immobile property, and those tenants would refuse to leave the property. So yeah, at that point of time, DMM or uh, or CM, so they might the bank might need the assistance of CMM or DM's assistance under section 14. Now remember, CMM is a term that is derived from old CRPC. I think it is replaced by CJM in the new BNSS, Chief Judicial Magistrate. However, the CMM and DMs are the terms that is retained by SARFAESI, so you might know that. If you want to, or if somebody asks, or if there is, very rarely this question might be asked. So these days, after the new BNSS, it is CJM and the DM. Moving on to the next, the security interest and enforcement rules. Like I said, they prescribe step-by-step method for selling security as secured assets, like how the valuation should be taken, what the title search is supposed to be done, the valuation. Like I said, if it is more than 1 crore, it must at least have two valuers, and a public notice has to be given. That is the most important thing. A clear gap of 30 days public notice has to be given for sale of property, and the sale may be by a public action or a tender or private treaty. Now, usually public action is the preferred route. In case if it is private treaty, be very careful that the borrower might change that the private treaty is done to ensure that the bankers get undue advantage. So the public auction is always the best method, but a private treaty is also a route that is followed by the authorized officers. However, private treaty ensure that the borrower is in line and he has no objections for private treaty, because usually when you go for public auction, the particular uh, property might fetch a better value. There are instances where the court have looked into the intentions of the authorized officers, that are the chief managers, on why they went into private treaty, and they have invalidated the SARFAESI action, or they have even raised fraud charges. So be very careful with that. But the SARFAESI Act allows the property to be sold by private auction, public auction, tender, or private treaty. So public auction is always the preferred method. Like I said, right of redemption. First of all, I wanted to explain what is the right of redemption. Right of redemption means it is the mortgager's right to redeem the property, and this right exists, not on very clearly. I will repeat and again. This rights exist only till the bank publishes the sale notice. If the sale notice is published, your right of redemption is extinguished. This is there in the act, and this is done after 2016 amendment, and this is also reiterated by the Supreme Court. Time and again, I have seen many borrowers file applications in DRTs or High Courts or Supreme Court after a sale notice is published. Look, there are enough time for the borrower to represent his case before the appropriate tribunal or the High Court or the Supreme Court before the sale notice is published. Now, during the 60-day period, like when the demand notice is issued, the borrower can give representation under 13(3)(a), and if that representation is dismissed, or if that representation is properly addressed with, the borrower has every right. Look, the bank can go wrong in many times. They might issue a kind of wrong kind of demand notice. The proper information in demand notice might be missing. They might calculate the balance wrongly. The valuation report can be wrong. So all this can be wrong. So the borrower has every right to challenge it. But once the sale notice is published, then your right of redemption is virtually lost. And so be very careful at that. This is a most often question. This can be tested in MCQ, that the right of redemption of a borrower, or the right of redemption of the mortgager, uh, which means the mortgager's right to redeem his property, is lost once the sale notice is published. So this is a very important thing. Next, distribution of sale provide proceeds. This is a waterfall mechanism. So the first goes to the cost and expenses of the sale, the cost of valuer, the cost of taking possessions, the cost of other things, publications and other things. Those are the first things that is appropriated. Next is the secured debt. It goes to the debt. And if there is a consortium share, then it is based on the interstate creditor agreements or consortium agreements. It is divided. And if there is a surplus, it goes to the borrower. And like I said, if there is no surplus, the bank or the financial institution uh, or the security has every right to do other methods. They can file a case in the DRT, or if there is already a parallel procedure going in DRT, they can pursue that option. And if it is a company, they can also pursue an insolvency proceedings. They can also file a civil proceeding separately. So all these things can be done by the banks to recover the balance. Just because a secured property is sold, it doesn't mean that the borrower's dues or borrower's default is clearly extinguished. And this is as opposed to what happens in insolvency proceedings. In insolvency proceedings, if there is a CRIP process, if it is done, then it means that the borrower's debts are virtually extinguished. But in SARFAESI, it is not like that. Even if the property is sold, the bank or the financial institution has every right to pursue other routes. Now, this is different from the CRIP procedure. If there is a CRIP that is passed by the community of creditors, then the borrower's debt stands extinguished, same as in liquidation proceedings. So, like I said, SARFAESI and DRT acts goes hand in hand, and they're not competitive to each other; they're complementary to each other. With this, we conclude this topic, and you can just try out the most important thing, that right to redeem a secured asset is extinguished before the publication of after the publication of the sale notice. And so today we have seen possession, what is symbolic and physical. The symbolic possession is not there in the act, of course. The physical possession is more attractive, but symbolic possession can is can suffice for a sale notice. Then there is enforcement rule, which talks about the fine integrity of how to publish the sale notice, what should be there in the sale notice, how valuation should be done, how title search reports have to be. And the section 13A talks about the redemption rights, the right to redemption. And this is the most important thing that you have to remember, that the right to redemption is virtually lost once the sale notice is published. Next, there are waterfall, and we have seen that even there is a recovery, shortfall recovery, the bank or financial has the right to approach other appropriate tribunals and courts for fulfilling the remaining debt. Now, with this, we come to the topic on possession sale in SARFAESI Act. If you have any doubt, please type it down in the comments. And if you feel any concept little bit tough to understand, do type it in the comments. I do read every comments, and I will ensure that I try and clear it. And do share it with your friend with whom this video would be helpful. Let's see in the next topic. The next topic would be magistrates assistants. That is, like I said, CJM or DM assistants. Thank you. All the best.